Hello, Professor. My name is Grel Wafula. This is my assignment 3 on privacy search and seizures. Okay, so we'll just go mm, to the first question. And the first question states that is evidence that is illegally searched and seized admissible in court? Yes or no, or depends. Explain in details. Why do you think this is the case? Are there any exceptions? If there are exceptions, name and discuss at least three exceptions. Name two relevant laws from each of the United States and Canada that relate to the evidence and its admissibility. Answer these questions for USA and Canadian law separately. Okay, so this question is whether evidence obtained through illegal searches and seizures is admissible in court in both Canada and the United States. The answer cannot be yes or no, but it depends on variety of the legal principles and rules and also exceptions, as we are going to discuss in the next slide. So the next slide, we are first discussing according to the United States law. So in the United States, the general principle is that evidence obtained in violation of the US Constitution is not admissible in court. This is due to the exclusionary rule based on the Fourth Amendment of the United States Constitution. It states that evidence obtained through illegal searches and seizures is inadmissible in court. This rule ensures that the government and its agency respects the constitutional rights of individuals during investigations and prosecution. But this law, there are several exceptions to this exclusionary rule, including the first exception is the good faith exception. Under this exception, evidence obtained by officers acting on a warrant they believe to be valid, even if it's found later invalid. The reason behind this exception is that not to punish the honest mistakes or errors made by the other actors in the judicial system. Also, we have the second exception, which is independent source doctrine, which states that under this exception, evidence initially discovered during an unlawful search, but later obtained independently through lawful means. For example, if a police illegally enters like a warehouse and observe evidence, but later obtain a valid warrant based on the information entirely independent of the illegal entry, the evidence seized under the warrant may be admissible in the court. Also, the third exception under this rule, exclusionary rule, it's inevitable discovery doctrine, which permits admission of evidence that was obtained through illegal means, regardless of the illegality. So, under the relevant laws, two primary laws from the United States relate to evidence and its admissibility in the context of illegal searches and seizures include first the Fourth Amendment of the United Constitution, which protects against unreasonable searches and seizures. This amendment provides the fundamental legal basis for the right to privacy and the requirement of warrants based on probable cause for most searches and seizures. A lawful search of seizures generally requires a warrant issued by the judge, and the warrant should be valid. Yeah. Also, we have the Federal Rules of Evidence, Rule 402, which states that irrelevant evidence is not admissible in court. So these two laws, I have just attached the reference link at the end of the of this chapter. So I'll just take you there after for the references. So let's discuss in Canada. In Canada, the admissibility of evidence obtained through illegal searches and seizures is primarily governed by the Canadian Charter of rights and freedom, specifically Section 8 and the Section 24. In Section 8, which is the right against unreasonable search and seizures, the Section 8 of the Canadian Charter of Rights and Freedom guarantees that everyone has the right to be secure against unreasonable search or seizures. The purpose of this section is to protect individual reasonable expectation of privacy from unjustified intrusion by the state. This protection extends to various aspects of privacy, including personal, territorial, and informational privacy. For a search or a seizure to be considered reasonable under this Section 8, it must meet three criteria, which the first one, it must be authorized by law. The law itself must be reasonable, and the manner in which the search is carried out must be reasonable too. Also, the Section 24, which is exclusion of evidence. Under this section of the Canadian Charter of Rights and Freedom allows courts to exclude evidence obtained in a manner that denies the right or freedom if admitting it will bring the administration of justice into disrepute. That's like disrepute is like the public system lacking the confidence in in the in the way the court rules. Like yeah, the focus is on maintaining public confidence in the justice system. So, like, if we conclude between the United States and the Canadian law, uh, yes, there is my conclusion. In conclusion, the admissibility of illegal search and seized evidence in both the United States and Canada is a matter that depends heavily on specific legal rules and exceptions. In the United States, the exclusionary rule rooted in the Fourth Amendment generally prohibits the use of such evidence to deter police misconduct and protect constitutional rights. However, this rule is subject to several significant exceptions, such as the good faith exception, independent source, and inevitable discovery doctrine. While in Canada, on the other hand, does not have like an automatic exclusionary rule like the United States. Instead, under Section 8 and 24 of the Charter of Rights and Freedom, court conducts a case-by-case analysis to determine whether admitting the evidence will bring the administration of justice into disrepute. This involves balancing the seriousness of the charter breach, its impact on the accused, and the society interest. Yeah. So these are the references. First, we have the references from the United States exclusionary rule, which is here. So let's just go to the reference. This one is the exclusionary rule as per the Fourth Amendment of the US law, USA Constitution. See the overview. The exclusionary rule prevents the government from using most evidence gathered in violation of the United States Constitution. The decision is in Marple versus Ohio, establishing the exclusionary rule applies in the evidence gained from the unreasonable search or seizure, the violation of the Fourth Amendment. So, for example, like this is a case that this rule applied. So, also there is another case between Miranda and Arizona. Yeah, so see, there are exceptions like the good faith, independent source doctrine, inevitable discovery doctrine. Okay. So we have another, the reference, which is here. This also to the Fourth Amendment and exclusionary rule. The Fourth Amendment of the United States Constitution prohibits police officers from conducting unreasonable searches and seizures. It requires law enforcement to have a valid warrant or probable cause. But what happens if a police officer performs a search or violation of the Fourth Amendment and finds incriminating evidence? That's what exclusionary rule comes into play. So like, this is this like the development to give us some brief how the rule came to be. Why do we need it? Yeah. So you can see like the some of more example of tainted evidence include like a wiretap recording between two defendants that the police officer seized without a search warrant, a confession the police got using forces. So these are just some examples. Yeah. Say like the good faith exceptions. Those are the exceptions. Okay. So we have this rule for two general admissibility of relevant evidence. So let's just go to it. It's from Cornell Law School. Mm, I'm looking for this one. Not all relevant evidence is admissible, like in the court. So the provisions that all relevant evidence is admissible with certain exceptions, and that evidence which is not relevant is not admissible are a pre supposition involving very conception of rational system of evidence. This is some of my references according to my research. Also, we have in Canada, let's go to the Canadian Charter of Rights and Freedom. Okay, you can see it's up some brief introduction page. Okay, so we can just see like the section 8, which is under here. Section 8 is there, which says that everyone has the right to be secure against unreasonable search of seizures. According to the Supreme Court of Canada, the purpose of the Section 8 is to protect a reasonable expectation of privacy. This means that those who act on behalf of the government, such as the police officers, must carry out their duties in a fair and reasonable way. They cannot enter into private properties or take things from other unless they can show. So we have some cases to this section 8, of which we'll just discuss each later. For example, like the case of the name, just every just check it. Yes. So this is on section 7, and this is number on section 8. So let's just say section 24, which also talks about so section 22 here. Section 22. Mhm. To- from my first days. Section 24. Yeah, this is introduction of Section 24 of the Canadian Charter of Rights and Freedom. Mm, mm, okay. So the second question is, how is the reasonable expectation of privacy test applied to computer system and data? Does an employee have a reasonable expectation of privacy in the workplace? What about at home? Discuss. Answer the entire question for Canadian law only. Provide two legal references from Canada. Regarding computer system and data, the Supreme Court of Canada has recognized that computers, whether they are personal or work related, often contain a vast amount of personal information, such as financial, medical, and as well as browsing history. Therefore, there is a generally a reasonable expectation of privacy in the information stored on computer system and digital devices. So let's first discuss the reasonable expectation of privacy in the workplace. The question of whether an employee has a reasonable expectation of privacy in a workplace, particularly on an employer-owned devices. The Supreme Court of Canada addressed this in a recall 2012. This is a case. The court held that an employee have a reasonable expectation of privacy in work-issued computers, especially where personal use is permitted or reasonable expected. The court in the recall case emphasized that the totality of the circumstances must be considered. These include the employer's operational needs, workplace policies, whether the computer is password encrypted, and the nature of information being accessed. Even with the employer policies in place, the Supreme Court of Canada has suggested that employees retain some expectation of privacy in, in personal information stored in work computers. So we can just check on this case, which I've just attached here. Let's just check the case. Mhm. It's from Canley. So you can just check, like, for example, this they accused a high school teacher. So this is the case of Cole. A high school teacher was charged with the possession of child pornography and unauthorized use of a computer. He was permitted to use his work-issued laptop computer for incidental personal purposes, which he did while performing maintenance activities. A technician found on the accused laptop a hidden folder containing the nude and particularly nude photograph of underage female students. The technician notified the principal and copied the photograph to a compact disc. The principal sees the laptop, and the school board technician copy the temporary internet files into a second disk. The laptop and and both the discs were handed over to the police, who, without a warrant, reviewed the contents, and then created a mirror image of the hard drive for forensic purposes. The trial judge excluded all the computer material pursuant to Section 8 and Section 24 of the Canadian Charter of Rights and Freedom. The summary conviction appeals that the court revised the decision, finding that there was numbers uh, of Section 8 breach. The Court of Appeal for Ontario set aside that decision and excluded the disc containing the temporary internet files, the laptop, and the mirror image of its hard drive. The disc containing the photograph of the student were found to be legally obtained and therefore admissible. As the trial judge had wrongly excluded this evidence, the Court of Appeal ordered a new trial. So this is just an example of a case that involved a high school teacher using his work computer on to store like the nude photos for an underage female student. So a technician found about the folder, told the principal about it. The principal who informed the police. The police get they took the matter into their hands. They seized the computer. They seized the evidence, but they did not seize the evidence in according to the section 8 of the constitution. So the court dismissed this case, and because they say that the rights of Mr. Cole was violated under section 8. Okay, so this is just the case, like shows how the case went. So okay. Mm, okay, so this is just the summary of events which happened, like you can say 24, 26. Okay, let's just continue with our discussion. Okay, reasonable expectation of privacy at home. This principle extends to the computer system and data within the home. Individuals typically take steps to secure their home computers and personal data, such as using passwords and storing sensitive information privately. Therefore, any state intrusion into a personal home to access computer system or data will generally require a warrant, which should be valid based on the reasonable and probable grounds. The Court of Canada decision in this case of Harvey Morel of 2010 underscores the high expectation of privacy individuals have in their personal computers found in their homes. The court described the search and seizures of personal computer such difficult to imagine such more intrusive, extensive, or invasive of one's privacy. This highlights the significant protection to digital information within the private sphere of one's home. So this is a case of Morelli. Let's just have a look at the case where he was. So yeah, this is the case. So we can just have a brief at it. Like, so this is a case that happened on September. A computer technician arrived and announced to an accused house to install high-speed internet connection to the accused has ordered. The accused lived with a wife and two children, aged 3 and 7, but was alone that day with a younger daughter. When the technician opened the accused web browser, he noticed several links to both adult and child pornography sites in the taskbar favorite list, including two that was labeled Lolita, that word, and Lolita, uh, the other word. So he also saw a legal uh, mhm, image, but he could not remember afterward if it was on the browser homepage or on the computer desktop. In the room, he noticed some home videos and a tripod, a webcam that was connected to a videotape recorder, and was pointed at the toys at the child. Unable to finish the work, the day the technician returned the following morning and noticed that everything has been cleaned up. The child toy has been placed in the box, the videotapes could no longer be seen, and the webcam was pointed at the computer user chair, and the computer hard drive has been formatted. So in November, the concern with the child safety, the technician reported the matter to a social worker who contacted RMCP. The technician made a statement to or in January 2023 after the interview, or consulted SPL from the RNCP Technological Crime Unit, who he knew had experience investigating crimes involving computers and technological devices. We stated that these types of offenders were habitual and will continue their computer practices with child pornography, and that their information will be remain inside the hard drive. So this is just the 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 case, how it went, and you can see at the trial he unsuccessfully challenged the validity of the search warrant under Section 8 of the Canadian Charter of Rights and Freedom. The trial judge convicted the accused, and majority of the Court of Appeal upheld the conviction. So this is just one a case. Um, yeah, these are the events, how they were recorded as they took place. Let's say, okay. On the two cases, like you can see the first case of Cole, you can see the Supreme Court of Canada as directly addresses the reasonable expectation of privacy in workplace computers. The court establishes that employees can have such an expectation, especially when personal use is permitted, but it can be diminished by the employer policies. And on the other case of Morelli, the Supreme Court of Canada case emphasizes the high expectation of privacy individuals have in their personal computers, particularly within their homes, due to the vast amount of personal information these computers may contain. So going to the third question, which states that does the concept reasonable expectation of privacy with respect to searches conducted by the police exist in the European Union? Does it exist in the United States? Discuss and provide at least one legal reference for each of the EU and USA. Okay. The concept of reasonable expectation of privacy stands as a cornerstone of individual liberty in a democratic society, safeguarding individuals from unwarranted intrusion by the state, particularly in the realm of enforcement. Here is a summary of comparison of reasonable expectation of privacy in policies such as in the EU and the United States. So the first one we'll just discuss in the EU. And in the European Union, the right to reasonable expectation of privacy in the context of police searches is protected under Article 8 of the European Convention on Human Rights, ECHR. The European Court of Human Rights interprets Article 8 to include this concept. Article 8 protects your rights to respect for your private and family life. Article so we can have just a look on the Article 8 as it is there on my reference. So there's a reference on the Article 8 of the EU. Okay. Article 8 talks about respect for your private and family life. Article 8 protects your right to respect for your private life and family life. So it goes deeper on talking about what private life means. Like you can say mm, you have a right to live your private life without government interference. So mm, also it goes ahead to talk about what family life means, what home means, restriction to the right of to respect your private and family life. There you go. You can see right to privacy. Everyone has a right to privacy to his private and family life, his home and correspondence. Mm. So there is a case here between Godwin and the UK, United Kingdom. Mhm. You can see the court ruled that this treatment violated both the right to private life and right to marry. The UK government later introduced the general. Okay, okay, okay. So can have another. This is another reference. Italian yearbook of human rights. It has compiled the cases under this article. You can see Article 8 of the European Union, Article 8 of the European Union Convention of Human Rights, balancing privacy, public interest. Okay. In 2024, the European Court of Human Rights case law of Article 8 of the European Convention concerning interrelated ongoing challenges of protecting privacy and family life, especially the right to respect for home and correspondence, the court address. So there you go. So you can see these are some of the cases where between the people and the government of Italy, according to these right to privacy. So you can see, like for example, this case of A&F and MF versus Italy. You can see the court ruled in the favor of AF and MF. So in this case, the government proposed a compensation of the euro 25,000 for moral damages and 1,000 for legal fees. The court recognized the agreement. This you can see. So this is the sum of the example of the cases that were ruled in favors of the people and against the government of Italy. So these are the cases. You can see. Mm, okay. So in the United States, the concept of reasonable expectation of privacy in police searches is protected by the Fourth Amendment to the United States Constitution, as we discussed earlier, which forbids warrantless searches are generally presumed unreasonable unless an exception applies. The exclusionary rule generally prevents the use of illegally obtain evidence in criminal trials, aiming to prevent the police from misconduct. So this is addressed in the Fourth Amendment of the United States, and the Fourth Amendment law I have just attached here. So you can see this is the Fourth Amendment that of the U.S. Constitution that provides the right of people to be secure in their persons' houses, uh, to be secure in their persons' houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon. Yeah, so can okay, so okay. In question number 4, in Canada, when does the government into brackets crown need a search warrant to search and seize suspect computer? Name at least two legal cases from Canada which are examples of permitted warrantless searches. Name at least two legal cases from Canada where the court disallowed a warrantless search. So in Canada, the government requires a search warrant to search and seize a suspect computer to protect the individual privacy under Section 8 of the Canadian Charter and Charter of Rights and Freedom. While in the general rule requires that a warrant to search and seize computer. Canadian law recognizes certain exceptions when where a warrantless search may be deemed reasonable. Warrantless search may be permitted with a valid consent. So, permitted warrantless search. Uh, okay, we have the search incident to lawful arrest, the sealer. Police can search a person and immediate surrounding upon arrest for digital devices like cell phone. Specific condition apply to ensure reasonableness. We have a reference to this. Let's just go to the reference. You can see it in this case. The case of Heron. You can see like this case. It involved two men. Uh, One armed with a handgun robbed a merchant as she loaded her car with jewelry. The robbers grabbed some bag, one of which was filled with jewelry, and fled in a black vehicle. The police became involved shortly afterwards. At that point, they had not located the jewelry or the handgun. Later that evening, they located and secured the getaway vehicle, and arrested the suspects. During the pat down, a search of F conducted incident to arrest. Police found a cell phone in F's pocket. The suspect. Police searched the phone at that time, and again within a less than 2 hours of arrest, they found a draft text message that we did it. We did it, but the jewelry at Niagara, bruh. And some photos, including one of the handgun. A day and a half later, when the police had a warrant to search the vehicle, they recovered the handgun used in the robbery and the one that and they depicted in the photo. Months later, police applied for and were granted a warrant to search the contents of the phone. No new evidence was discovered. Yeah. Mm. Mm. So you can see the power to search incident to arrest in extraordinary, in that it permits reasonable searches when the police have neither a warrant nor reasonable and probable grounds mm, that the exercise of the extraordinary power has been considered in general to meet constitutional master reflects the important law enforcement objectives which are served by searches of people who have been lawfully arrested. This power must be exercised in a pursuit of a valid purpose related to the proper administration of the justice, and the search must be truly incidental to the arrest. Okay. So we have this one. Exigent circumstances, a warrantless search is allowed if obtaining a warrant is impractical due to imminent danger of or risk of evidence loss. So we can just have a look at it. There you go. This is a case that involved a police officer uh, seizing a cell phone during a such incident of an arrest. You can see the arrest of G, a drug dealer, a few minutes after G arrest. Four text messages from the sender. D reached the lock screen of the phone, appearing to offer to sell drugs to G. Over the next 2 hours and 15 minutes, the police, without a warrant, replied to the text message, to the text impersonating G, and encouraged the sender to come at the G's residence to deliver the drugs. When the accused came to J's residence that evening, he was arrested and found in possession of heroin laced with fentanyl and was charged with drug trafficking and possession of offenses. The accused claimed that he did not send the first four texts that they had given him the phone to arrange the delivery of drugs to J. However, the accused did not acknowledge that he sent the received text to J. So you can see that on this case, can see here, the Court of Appeal accepted that the accused had a reasonable expectation of privacy in his text message conversation and thus had a standing to argue that the police violated his rights under Section 8. However, it concluded that the search was justified by exigent circumstances under Section 11 of the CDSA. Accordingly it dismissed the appeal. So disallowed warrantless searches. We have Jim Reeves, a seizure of a shared computer based on the spouse consent was a charter violation. So we have this case on Jim Reeves, where the wife consented on his behalf, but the case was disallowed. Yeah, so you can see the accused shared a home with his common law spouse. Following charges of domestic assault against the accused, a no contract order was issued, which prohibited the accused from visiting their home without his spouse prior written and revocable consent. When the spouse contacted the accused probation officer to withdraw consent for him to enter the home, she reported that she found what she believed to be a child pornography at the home computer, which she shared with the accused. A police officer came to the family home without a warrant. The accused spouse allowed the officer to enter and signed a consent form authorizing him to take the computer, which was located in a shared space in the home. The police detained the computer without a warrant for more than 4 months before searching it. They also failed to report the seizure of the computer to a justice despite the requirements of Section 489, Lot 1 of the Criminal Code. When the police finally obtained a warrant to search the computer, they found 140 images and 22 videos of child pornography. The accused was charged with possession and accessing child pornography, but applied to exclude the computer-related evidence, claiming that his right to be secure against unreasonable search or seizure pursuant to Section 8 of the Canadian Charter of Rights and Freedom had been violated. The application judge agreed. Accordingly, he excluded the computer evidence under Section 24 of the Charter, and the accused was acquitted. The Court of Appeal allowed the Crown appeal from the acquittal, set aside the exclusionary order, and ordered a new trial. Yeah, so that's one example of a disallowed case. Also, we have this one that we discussed earlier that involved Cole and the content of the content that he had. Cole was a, a, a high school teacher, and in his work computer, he had some nude photo of a student. Then a technician found the content, he reported to the principal. The principal who involved the police officers. Cole was put into trial, but the judge disallowed the case due to the violation of Section 8 of the Canadian Charter. Yeah, so let's go to the next question. Explain the concept of exigent circumstances under Canadian law. Which type of exigent circumstances might arise in respect to computer data and digital forensic? Discuss, provide one legal reference from Canada. So in Canadian law, exigent circumstances are specific situations where the need to take immediate action overrides the general requirements to obtain a search warrant. These circumstances typically involve an imminent threat to public safety or a risk of the immediate loss of destruction of evidence. Because these situations demand swift action, officers may be legally permitted to conduct a search or a seizure without a prior judicial authorization. So let's look at the several types of exigent circumstances might arise, such as the risk of data deletion or destruction. That's one. Like electronically stored information can be easily and quickly deleted or altered remotely if there is a reasonable belief that a suspect is aware of a suspect of an investigation and might imminently delete crucial evidence on a computer. This could constitute exigent circumstances for an instance if police are in the process of arresting a suspect who is actively using a computer and there's a concern, they might trigger a remote wipe or quickly delete files immediately. Immediate intervention to secure the device and its data might be justified. Also, if there is ongoing or imminent criminal activity, if a computer is believed to be actively facilitating an ongoing crime that possesses an immediate threat, such as a terrorist act, the need to access the data to prevent further harm could be considered exigent. Threat to life or threat to life or safety. That's our number three. Okay, like in situation where there is a credible and immediate threat to someone, life to safe or safety, and information or computer is believed to be critical to preventing that harm. Okay, one legal reference from Canada that illustrates the application of exigent circumstances in the context of digital evidence. The Supreme Court of Canada case of Campbell, 2024, of the case that we discussed a bit earlier, that in this case, the police seized a drug dealer cell phone during a lawful arrest, believing that the ongoing drug trafficking potentially involving fentanyl was occurring via text message. So one of the police officers impersonated the dealer to continue the conversation and lure the other person to come to the suspect place. So the Supreme Court found that the warrantless search of the accused text message conversation was justified by exigent circumstances. So the court reasoned that the urgency of the situation and the potential for immediate harm to the public made obtaining a warrant impractical in that specific context. Yeah. So we just have here some example, like some references to a warrantless search in exigent circumstances. Let's just take a quick look. Yeah. A warrantless search or a seizure is pre presumptively reasonable. However, where there are exigent circumstances, a police officer may forego the requirements of a search warrant. The requirements for a seizure under exigent circumstances are there's imminent threat to the public or public safety. We stated that in our reasons. The risk of loss of destruction of evidence, we also stated that one. So you can just see. So this is according to this in the US, but it is in the country. You can see that we have some cases here, like this one. Okay. Protecting life and public safety, another reason. Okay. So this is the case, but we had a quick look at the case a bit earlier. You can see this is the case. See, so you can see blah blah blah. The police, drug dealer. The police impersonated him. So you see here, the Court of Appeal accepted that the accused had a reasonable expectation of privacy in the text message conversation and thus had a standing to argue that the police violated his rights under the Section 8. However, it concluded that the search was justified by exigent circumstances under Section 11. Yeah, okay. Okay, moving to the next question, it states that what should a computer forensic investigator do if a computer that is being searched is found to contain privileged information? Discuss and provide one legal reference from Canada. So, if a computer that is being searched is found to contain a privileged information, a computer forensic investigator should first of all stop, should immediately cease reviewing the specific information and follow the established protocols to protect the privilege. When privileged information is encountered during a computer search, the investigator should take the following steps as stated below. First, he should halt the review. The investigator must stop examining any files or data that appear to be a solicitor, like lawyer-client privilege, or related to anticipated or ongoing litigation. Continuing to review such information could potentially waive the privilege. Identify and segregate the privileged information. Identify and segregate as number two. The privileged information should be identified and, if possible, logically and physically segregated from the other data being examined. This might involve noting the file names, location, or types of documents without reviewing their content further. Notify relevant parties. The investigator should inform the supervising parties, the legal team involved in the investigation, or the client or the owner of the computer about the discovery of potential privileged information. Follow established protocols. Many organizations and law enforcement agencies have specific protocols in place for handling privileged information encountered during searches. This protocol might involve specific notification procedures and the use of privileged review teams and the involvement of independent counsel. Consider a filter team. In some complex investigation, a separate team of individual, often lawyers, may be used to review the potentially privileged materials and determine whether the privilege applies before the primary investigation team assesses the information. Also, the sixth uh, the sixth step is seek legal guidance if there is any doubt whether information is privileged or how to handle it. The investigator should seek a guidance from a legal counsel. A lawyer can provide advice on the scope of the privilege and the appropriate steps to take to protect it. So I have some references here on protection of legal privilege and seizures of electronic data. Case on Lavelle. These were some group of lawyers, Lavelle, Raquel, Haynes versus the Canada Attorney General. So this case involved um, say this issue is brought before the court. Mm, I can see this appeal bring into question whether Section 488.1 of the Criminal Law Code, which sets out a procedure of determining a claim of solicitor privilege, client privilege in relation to documents seized from the law office under warrant, infringes Section 8 of the Canadian Rights and Charter, and if so, whether the infringement is justified under Section 1. This procedure mandates that the material to be sealed at the time of the search, that the solicitor make application within the strict timelines for the determination that the material is indeed protected by privilege and that the permission of the court, the Crown may be permitted to examine the material in order to assist in the determination of the issue of the existence of privilege. So it's just a case. Okay. So mm, mm, okay, it is the same case. I think I copied it twice. Yeah, yeah. Okay. So going to number 7, it's a question that what is MLAT and why is it important? How, why, and when might it be used? Give one legal reference where MLAT was used in Canada. MLAT first stands for Mutual Legal Assistance Treaty, which is an agreement between two or more countries that establishes a formal process for them to cooperate and provide assistance to each other in criminal investigations and prosecutions. MLATs are important because they facilitate international cooperation in combating cross-border crime when criminal activities extend beyond national borders. MLATs provide a legal framework for countries to help each other in the investigation and ensure that criminals cannot evade justice simply by fleeing to another country. So, MLAT might be used in various situations, including when, number one, evidence or information needed for a criminal investigation is located in another country. A suspect or a witness is residing in a foreign country and needs to be formally brought in question. Financial records or other documents relevant to the criminal case are held in a foreign jurisdiction. Law enforcement needs to request searches, seizures, or the freezing of assets located in another country. Canada has the Mutual Legal Assistance in Criminal Matters Act, which govern how Canada makes and responds to requests for mutual legal assistance. So the Mutual Legal Assistance of Canada, we can just, this is a link, we can just see it. Uh, let me just show you, which you can see, can hear. Mm, Mutual Legal Assistance request to Canada. Request made under treaties and conventions or by designated entities. You can say the mutual legal assistance in criminal gives Canada the legal authority to obtain court order on behalf of the countries and the parties to mutually legal assistance in agreement in Canada. This include bilateral treaties and say, so you can see the types of court-ordered assistance available in Canada. You can see we have the search and seizure, gathering physical and documentary, compelling witnesses to give statements, transferring sentenced persons to the requesting countries, learning court exhibits, examining a place or site in Canada, enforcing, restrain. Okay, okay, you can say. So, so we have here a case involving Canada and the UK where MLAT was used. So this is just a case I found it. You can see it is a case that involved. You can see it is in Canada. The use of MLAT was recently considered in the case of Raj Saramat. The name in Rajaratmat. Uh, Four accused were charged with organizing, inducing, and aiding in abetting people to come into Canada, like which is human smuggling. So in yeah, so the UK government wanted to. This was the like it was a case. So they wanted to arrest this victim who was smuggling people to come into Canada, and he was living in the UK. So, so you can see from here. Okay, this is the case of. Looking for, you can see the accused were acquitted of human smuggling charges. They were based in the UK, but they were smuggling people into Canada. So the Canada intervened with the government of the UK for for those people to be brought into custody. So they used the MLAT to help the MLAT that they have with the UK to bring the people the suspects into custody. The number 8 question states that name three privacy principles used elsewhere in the world that are not part of Canada's 10 privacy principles. Explain the utility of each, as well as any associated problems. Provide two legal references in total from anywhere in the world related to your principles or any one of them. So, the first principle in our discussion is data minimization. The principle emphasizes that Organizations should only collect, process, and retain personal data that is strictly necessary for the specific purpose or purposes for which it is collected. So the utility is like the usefulness of the purpose that they're trying to achieve. So, for example, like the utility of this principle, first of all, data minimization reduces the risk of data breaches and limits the potential harm if a breach occurs, as less data is exposed. Yeah. So the second one is also it can also lead to cost savings if data storage and in data storage and management. Furthermore, it enhances trust with individuals by demonstrating commitment to privacy and avoiding unnecessary data collection. But also, it has associated problems with this principle, like the implementing the data minimization can be a challenging as organization may struggle to determine what data is truly necessary, especially for future or unforeseen purposes. It can also conflict with business objectives that might benefit from collecting and analyzing the large data sets. Legacy system and complex data ecosystem can further complicate the process of identifying and deleting unnecessary data. Yeah. So that's our first principle. Let's see the second one, which is purpose limitation. This principle dictates that the personal data should be collected for specified, explicit, and legitimate purposes and should not be further processed in a manner that is incompatible with those purposes. The utility of this principle is purpose limitation. First is purpose limitation ensures transparency and gives individual control over how their data is used. Also, it prevents organization from collecting data for one reason and then using it for unrelated or unexpected purpose without the consent of the user of the of the person whose data is being collected. This principle is crucial for maintaining trust and also complying with the privacy regulation. Also, its associated problems include the rise of big data and advanced analytics, which often involve combining and repurposing data for new insights, can clash with the strict application of purpose limitation. It can be difficult for organizations to anticipate all potential future uses of data at the time of collection. Defining purposes too broadly to accommodate future uses can undermine the principle's effectiveness. Uh, Also, we have uh, number three, which is accountability. And this principle of accountability states that organizations should be responsible for the, the personal data that they collect. So they should be responsible on how they use it and how they keep it. So they should take full responsibility. So the utility of this principle, a strong accountability principle encourage organization to implement robust data protection policies, procedure, and technical measures. And also, it fosters a culture of privacy within the organization and ensures that there is oversight and responsibility for handling personal data appropriately. Demonstrating accountability also build trust with customers and also regulators. The associated problems of accountability of this principle include accountability can be challenging to implement effectively, potentially becoming a bureaucratic exercise without truly impacting data protection practices. For yeah, ensuring accountability across complex organizational structures and supply chains can be difficult mm, yeah, to implement. There can be challenges in consistently demonstrating compliance in the face of evolving technologies such as the uh, regarding to technologies such as the AI. Yeah, so because um, there are no main implementation governing AIs on how they use information, how they collect information for people. Yeah, but it is something which is in discussion. So here I have some references to this, why data minimization is important. So this is just a reference to data minimization. Mhm, mhm. Okay, so okay, can check this is on GDPR. Okay, let's check on mhm, mhm. Okay. Mm, think, mm, uh, okay, this is the principle of the GDPR, accountability. So we discuss in our presentation. So, okay. Okay. Question number 9. What is the difference between privacy and security? Which is harder to maintain? Justify and explain your answer. Okay. Privacy, it refers to the individual right to control their personal information and decide who can access, use, or who can also share it. It's about confidentiality and the expectation that certain aspects of one life and personal data will be kept private. On the other hand, security involves the measures taken to protect information from unauthorized access, disclosure, disruption, modification, or destruction. It's about safeguarding data through so we have it's about safeguarding data through the technical, physical, and administrative. Those are the security controls to ensure confidentiality, integrity, and availability. Strong security measures are often necessary to ensure privacy, but security alone does not guarantee privacy. For example, data might be securely stored but still collected and used in the ways that individuals do not expect or consent to. So that's a key difference on privacy and security. Yeah, but they okay. So uh, in my case, I were between security and privacy, which is harder. Uh, on my point of view, security is arguably harder to maintain than privacy because I have stated some reasons here, which include the following, like for example, the evolving threats, such as the security faces constant threats from cyber attacks and vulnerabilities, such as the ransomware attacks. Also, we have human error, Like a single mistake can compromise a security. For example, you can see like a company may have like strong security. They have implemented this like strong security controls, yeah, like firewall, success control, but maybe a phishing email maybe from somewhere, and the employees when they are not careful, they click to the phishing emails, which is an attack. Then all of the attacker may have those information. Yeah. So also sometimes you can see like privacy can sometimes be legally enforced because we have like the privacy laws such as the GDPR, California, the PIPEDA, but you see security requires continuous monitoring and upgrading of the system. Yeah, so in my case, I see like implementing the security for an organization it is difficult, unlike implementing like privacy. Yeah. So security, in my point of view, is harder to maintain. Yeah, because also with the evolving technologies, it constantly, which constantly evolve with time to time. So we need to upgrade our security system now and again. Yeah, so that's my point of view. So come to the next question, which states that what is a peer? When should when should one be performed? What types of findings are typically uncovered as a result of performing a peer? Are peers legally required to be performed in Canada? If so, under what circumstances? Discuss. So, a privacy impact assessment, which in short is a peer, it's a risk assessment tool used to evaluate how an organization collects, use, and stores personal data. It helps identify and mitigate privacy risk. A peer should be performed when an organization is introducing a new program, service, or a policy that involves the collection, use, or disclosure of personal information. It is also necessary when there is significant changes to existing program or information system that affect how personal information is handled. So, when should a peer be performed? Number one, before launching a new technology, for example, like if you want to launch a facial recognition system, the peer should be performed. When handling sensitive information, personal data such as the health records, financial data. So those are a few of maybe the data that when implementing new laws or policies that affect privacy, when personal information is disclosed without consent for study, research, or statistical purposes. This is in provinces like Quebec, okay, before transferring personal information outside Quebec. Right. The findings of APIA typically uncovers various types of privacy risks and areas of improvement such as unauthorized access to personal data as number one, data breaches, excessive data collection. So this is just the same like data minimization, where we uh, collecting more information than necessary here. Mission creep, using data for purposes beyond the original intent. Inadequate data retention or disposal practices. Insufficient transparency about data practices. lack of user control over personal information, failure to obtain proper consent for data processing activities, risky data transfers, gap in security measures, lack of awareness among staff about privacy protection, and clear roles and responsibilities regarding data handling. Okay, so we have this question. Are peer legally required in Canada? Yes, peers are legally required to be performed in Canada under certain circumstances. Mm, okay, well, isn't a single law mandating peers for all organizations across the country. Several pieces of legislation and government directives require them. For example, the one is the federal government, the Treasury Board of Canada, TBS, directives, directive on privacy impact assessment mandates that federal government institutions conduct peers for new or substantially modified programs and services that raise privacy issues. Okay, the Quebec Acting respecting the protection of personal information in the private sector. Law 25 requires in a private company to conduct peers for projects involving the acquisition, development, or overhaul of information system or electronic services delivery systems that handle personal information as well as before transferring personal information outside Quebec. In BC, Section 65 of the Freedom of Information and Protection of Privacy Act requires public bodies in BC to conduct peers. Okay, so we have the reference. This is from the BC. This is from BC. Yeah. Mhm. Mhm. Yeah, so I can just say it states that peers are necessary. You can say like first one, cancel head of ministry must conduct a peer and must do in accordance to directions of the act. There you go. Ah, so it's listed here. Okay, okay. So we have here. This is a reference on how to do privacy impact assessment. Let's see. Okay, we go. See, like an example of how to when a peer is necessary. See if your project, for example, like this one, a new IT that collects all personal information. So in situations like this one, a peer is necessary. So it's a, yeah, so it's a wonderful article. Yeah. Okay, so the other question, it was there are five links linked below. This investigation were conducted by privacy commissioners in Canada or in Australia. Select one of the five links, read it carefully, then summarize the selected investigation report, discuss the report in the context of our classwork, including privacy, search, evidence, and computer security. Critique the report. Do you agree with the approach, with the analysis, with the conclusion? Discuss and provide two legal references from Canada or Australia as applicable. So in my case, I chose this report. Let me just show you. Yeah, this is the one that I chose. So you can just have a brief summary over here and see what the reports entails since it's a long one. But I have detailed it in my presentation. So you can see a requester, a patient of the university health network, the hospital, source records from the hospital regarding allegation of improper conduct that were made against him by another patient. The hospital located on record responsive to the complaint request. The hospital issued a decision denying access to the record on the basis of the exemption of the Freedom of Information and Protection of Privacy Act, FIPA, for the solicitor client privilege under Section 49, in conjunction with Section 19, and personal privacy, Section 49, and the Personal Health Information Protection Act, FIPA exemption for legal privilege under Section 52, and confidential source, Section 52. In this decision, the adjudicator finds that the records contains personal health information of the compliant and other individual. The adjudicator considers the compliant right to access to his personal health information under FIPA and FIPA. She concludes that since the record is not dedicated primarily to the compliant's own personal health information, he will be entitled to have access to only his reasonable severable personal health information. However, since the record as a whole is a subject to solicitor-client privilege, which has not been waived, she opposed the hospital decision to deny access to the record in full. The adjudicator also finds that the research conducted by the hospital in response to the complaint access request was not reasonable and orders the hospital to conduct an additional search. So that's just a summary of that case. So I've just detailed it here. So the FIPA decision 1-1 concerns like the investigation initiated after a complaint was lodged against a healthcare provider for allegedly mishandling personal health information under the Ontario's Personal Health Information Protection Act, FIPA. So here are some key details below. Let's just discuss. So the nature of sorry. So the nature of the complaint. The complaint alleged that the healthcare provider accessed, used, or disclosed sensitive health information without the proper consent or legal authority. The concern was that such practices breach the FIPA strict privacy requirements. Okay, so um, so the investigation process first was review of the policies of the procedure. The Information and Privacy Commissioner conducted an extensive review of the provider internal policies regarding the personal health information management This include examining how personal health records were collected, stored, and accessed, and also how they were shared. Also, digital forensics and evidence collection. Investigators performed a detailed search of electronic records, including system logs and access histories, to trace the flow of that information and identify any unauthorized access. The digital forensics analysis was critical in establishing whether there was a pattern of uncompliance. So the another other investigation process, there was assessment of technical safeguards. The investigation evaluated whether the provider had implemented robust technical safeguards such as encryption, secure data authentication, and effective access control. It examined that if the existing computer security measures were sufficient to protect the personal health information from unauthorized access or breach. Compliance check. The commissioner compared the provider's practices with the statutory required under the FIPA to determine if there were any deviation that compromised the patient's privacy. So let's to the findings and the outcome. The investigation found gaps in both the technical security and administrative processes. In particular, there were deficiency in how access control were managed and how regularly security measures were updated to protect against evolving threats. As a result, the decision concluded with recommendation that the healthcare provider enhance its security protocols, update its policies, and implement additional measures to safeguard personal health information and more effectively. So the second part was to discuss this context based on our classwork. The first one was privacy. So privacy is the okay. So according to our classwork, at the heart of our class discussion, privacy is the notion that privacy is a fundamental right. FIPA decision 101 reinforces this by holding healthcare providers accountable for protecting sensitive information. For example, like the real world application of privacy, the case demonstrate how legal framework like FIPA are applied to ensure that the patient data remains confidential. It illustrates the importance of obtaining explicit consent and ensuring transparency in handling of data practices. So the second one was search and evidence. We can see like the digital forensics in actions, for when they are doing the investigations. The investigation utilized techniques that we studied in class, such as searching through electronic records and analyzing system logs. This is a practical example of how digital forensic methods can uncover unauthorized data access and verify compliance. Importance of evidence. Just as we learn about the necessity of gathering solid evidence in our coursework, this case shows that meticulous documentation and log analysis are essential to substantiate privacy breach claims. Computer security. Technical safeguards. Computer security measures such as encryption, secure authentication, and regular system audits are vital in protecting the personal health information. The case emphasizes that technical vulnerabilities can lead to privacy breaches if not properly managed. In our class discussion, we stressed that privacy protection is not only about having strong policies, but also implementing and continuously updating our technical defenses that prevent unauthorized access, so that we can maintain our information to be confidential. The CIA triad, yeah. So the FIPA decision on 01 is clear example on how both administrative and technical measures must work hand in hand to safeguard the personal health information. So the 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 other part was the critique of the report, discuss the approach and analysis. So in the we have the strength, like as stated in the report, the investigation is comprehensive, yeah, integrating both legal review and technical analysis, also by examining system logs, reviewing internal policies, and assessing security measures. The commissioner was able to build a well-rounded case. The methodology mirrors the digital forensic and evidence-based approach we have discussed in class, ensuring that conclusions are drawn from a robust and systematic investigation. Uh, So the areas of improvement, while the investigation was detailed, it could have benefited from a deeper exploration of the operational challenges faced by healthcare providers. For example, resource constraints might explain why some technical safeguards were not as robust as expected. Uh, the report could expand on how emerging technologies such as the advanced encryption methods, real-time monitoring tools might further mitigate similar risks. A forward-looking perspective will provide a more comprehensive roadmap for ongoing improvements in data security. So in my conclusion, the FIPA decision 101 is a practical illustration on how privacy laws and digital forensic techniques and computer security measures intersect in the real world scenarios. For it shows that in an organization, privacy is paramount, especially when we're dealing with health information. Evidence and collection through digital forensic is also crucial to verify the compliance and uncover the gaps in the security controls. Yeah. In a, Also, robust computer security must continuously be updated to safeguard against unauthorized access. So overall, I agree with the approach and the analysis presented in the decision. The thorough investigation and clear recommendation demonstrate a strong commitment to upholding privacy standards. However, incorporating more detailed context about operational challenges and future-proofing security measures will further enhance the report's applicability in real-world settings. So, for for my references, I have two references here. One is from the Personal Health Information Protection Act, the FIPA, 2004 Ontario, and this legislation outlines the rules for collecting, using, and disclosing personal health information in Ontario. It provides the legal basis for the investigation and underscores the importance of patient consent and data protection. So let's just have a look at it. Mm. The rule. Okay, can see the purpose. The purposes of this act are to establish rules for the collection, use, and disclosure of personal health information about individuals that protects confidentiality of information and the privacy to provide. So, mm, so like a health information custodian that uses personal health information about an individual shall take responsible steps to ensure information is accurate, complete, and up to date as are necessary for purpose in which it uses the information. So, and also we have the second reference from the which is the Freedom of Information and Protection of Privacy Act, the FIPA. Yeah, can just have a look at it. So here, to protect privacy of individuals with respect to personal information about themselves held by institutions and to provide individuals with the right to access that information. To provide right to access the information under the control of institute in accordance with the principles, information should be available to public, necessary exception. Okay, so this is my second reference. And that has been my presentation, Professor, on assignment 3 on privacy, searches and seizures. And I hope you will like it and you'll suggest the areas of, of improvement on how I'll get better in my presentations, and also I'll take it as a step in a learning step. Yeah, thank you. I hope you have a good day or you have a good time. Thank you, Professor. I'll stop sharing.